Hey everyone, welcome back to the channel. In today's video, I've got a few sovereign citizen updates involving some familiar fictional corporate entities I've covered before. We're starting in Michigan with an update on one of the most infamous sovereign morons I've ever featured, Jal of the family Lockhart. He doesn't actually appear in today's clip, but another individual with the last name Lockhart does. And Judge Perkins from the 36th District Court of Michigan makes it very clear. He has an excellent memory and never forgets a face or a name. Last time we left this case, Judge Perkins ordered the softer to serve 30 days in jail for contempt of court, and that sentence had to be completed before the case could proceed any further. So let's jump right in.
Let's go call the city of Detroit versus, is that Amir Lockhart?
Lamar Lockhart.
Lamar Lockhart? I'm having difficulties with this gentleman here.
Oh, okay.
Lockhart. I'm looking for an Amir Lockhart. Mr. Lockhart, didn't I ask you this before? Were you in front of me before?
Yes.
Do you have a video?
Yes, I gotta flip it around, so I got you.
You're not the sovereign citizen Lockhart, are you?
You mean sovereign citizen?
Have you ever espoused any of those sovereign citizen views? I asked you the question.
I said no. Can you hear me?
Hey, flip your camera over. You're not in the toilet, are you?
Oh, I'm in the locker room.
Oh, very well. All right. You're not you're not the Lockhart that has the sovereign citizen views that we had a couple of years back. I'm taking that as a yes.
No. Can you hear me?
I can hear you.
Yes. No, a couple years back, no.
Have you ever come in front of me with the sovereign citizen argument?
No.
Have you ever come in front of any judge with a sovereign citizen argument? All right. This is City of Detroit. I have Jamil Amir Lockhart. Case number SP1247989, counts 1 and counts 2, and count 3. SP1706461. Appearance for the record, please.
Judge,
yes.
On the docket, this is not Simon Lamar?
He's not on the docket. He's I guess walking in now. What?
No, we have him on the docket. Simon Lamar Lockhart for Vassal Johnson at 8:35.
So am I looking at the wrong Lockhart?
The last name is hyphenated, if that helps.
Lockhart
hyphen
Simon.
Simon. Simon.
Okay, that would change things.
Okay. I was a little worried for a second.
And Judge, I remember the face of the gentleman you're talking about. This is not the gentleman.
And this is not Jamil Amir Lockhart. That's the one we're looking for, right?
Yeah, the one you're asking about. Yeah, this is not that gentleman.
Okay.
That's definitely not a good thing, especially when a judge has a memory that's sharp. 2.5 years later, and he still remembers you well enough to recall your full name just from hearing your last name. The last time he saw this guy was 2.5 years ago, and yet here we are. But before we move on to the next case, let me take a moment to talk about today's sponsor, Aura. Over the past few months, multiple major data breaches have come to light. First, 700 Credit reported that roughly 17.5 million people had their names, addresses, and social security numbers stolen by bad actors. Then Instagram revealed that 17 million instances of personal identity data were scraped through their API and leaked onto the dark web. That's where Aura comes in. Aura offers credit reporting and identity monitoring that alerts you anytime your personal information shows up online. They also provide a credit lock feature, which prevents anyone, including you, from opening new credit accounts without authorization. On top of that, Aura submits data removal requests on your behalf when your information appears online, and companies are legally required to comply. One of my favorite features is their VPN. Since I travel overseas often, there's no better way to stay protected on public Wi-Fi networks like hotels than using Aura's VPN. If privacy and security matter to you, I highly recommend checking them out using my link at aura.com/teamscoepic for a 14-day free trial. Plenty of time for Aura to scan the internet and alert you if you've been breached. Huge thanks to Aura for sponsoring today's video. Now, let's move on to our next case.
Good morning, Mr. Pierce.
Good morning.
How are you?
All right.
Good. It's been a minute. I'm gonna try it again. Your mom has been calling saying, "Where's Discovery?" And my staff explained that I tried before to give it to you, but we got a little sideways on some other things. This is the Discovery in your case. Although the bag you brought in looks like it's got a whole lot of stuff. That's not Discovery in there?
No.
That's your legal research, etc.?
Yeah, a lot of issues and stuff I need to discuss with you.
Okay.
And I have some documents and stuff I need to give you too. But my problem is I was supposed to be getting notarized today. All last week I've been trying to get my documents notarized, and the notary haven't been at the jail, so
Okay.
I was going to mail it out last week, but I'm still, I had my family called in the jail and asking them why haven't they came up and notarized my document that my family brought to the jail for me to sign and notarize.
Yeah.
So I'm having issues with it, but I was supposed to be sending to you, the DA, and the court clerk certified mail, but
Okay.
they haven't notarized any of my stuff.
Well, we'll wait on it. I mean, if you need it notarized, you should get it notarized. I don't know how frequently the notary comes, but that's different from you getting the Discovery. So I'm gonna give this to Deputy Gordon. He's gonna add it to your big old bag there, but this is all of the paper Discovery. And I say paper because there may well be some video, whatnot, but as you're reading through that, if you identify that there is video or audio Discovery and you want to watch it or listen to it, you just need to let me know. We'll bring you over here so you can watch it or listen to it.
Okay.
All right.
And I want to discuss about the recusal, and by you denying my recusal on ground that my recusal affidavit wasn't notarized, and I had the counselor email you and tell you that he in fact notarized my recusal.
So the one I have isn't notarized. So I ruled on what I got. I did not receive a notarized anything.
Reason being because the counselor Glenn, his notary is not the ink stamp. It was the press that the engraving in the paper. So when you send the copy, when you get it copied, because my copy didn't have it on it either, but it was in fact notarized.
Okay.
And I had counselor, I even documented his book when he notarized it and everything. I had him email you to in fact show you that if you put the original document, it was notarized.
Okay, could be. You're welcome to renew your motion if you want to, but the one that I received wasn't notarized. At least I couldn't tell that it was notarized. You've helped me understand that maybe there was some kind of one of those, I think they call it embossed.
Oh, that was called.
Yeah, but that wasn't evident from what you submitted. So if you want to file other things, you're welcome to do that.
Is no way you can put the original document and see that it was notarized?
Where would the original document be?
With the court clerk. I sent it to her, then I got to understand, she's not going to file no affidavit if it wasn't notarized.
Okay. No, she's going to file whatever you give her. That's their job.
Because I have sent the document before or affidavit and it wasn't notarized. She sent it back saying that it wasn't notarized, and I had to get it notarized and sent it back.
Okay. Well, I'll tell you what. I will see if there's an original. I just usually see electronic things, but if they've got a paper version, I can take a look at it.
Yeah, because he said the counsel said the reason he do that stamp because they can't copyright it or something. Something he said, so he do the engraved one. They engraved the stamp inside the paper. Yeah. And it's not the ink. It's not the ink kind.
I'm guessing they stopped using ink notaries once they realized you couldn't resist licking the notary stamp straight off the paperwork.
All right.
Either way,
I can still give you a copy of my document even though they're not notarized.
What is the document?
It's the Declaration of Authority and Assignment that Donald Trump signed off this year, September 30th, saying that I have a right to practice my sovereignty. Because we had an issue by you saying that I don't have individual sovereignty. And the declaration that Trump signed September 30th says that I do. I have a document with my legal notice and demand saying that I have the status of a foreign diplomat, which means I have a foreign sovereign, which means I have foreign sovereign immunity, which is a law that the United States adopted with all the other countries, which say that only way I'm not immune from the court, federal or state jurisdiction is when they're seeking money damages for personal injury or death, which also proves that I do have individual sovereignty. I have my acknowledgement and acceptance of all charges requesting different information that I'm asking for. I have my common copyright notice that says that the courts are in breach of my common law copyright notice because my name is copyrighted and trademarked, and there's remedies for breach that I have to give to the courts also.
Okay. Why do you think any of those things require an affidavit that's notarized?
Because let me show you.
You don't need to show me anything. You're doing a good job of describing. Just describe, because the things you're describing, I've seen some of that stuff before, but it doesn't usually come with an affidavit. But if you think it needs an affidavit and the affidavit needs to be notarized, then now wouldn't be the time to get that to me. You should wait till the notary makes the rounds.
She's supposed to come today, and by me being here, probably gonna delay it.
Oof.
Because I have a time for this one document, this acceptance and acknowledgement acceptance paper. We have a deadline for y'all to respond to my paperwork. So I still want to be able to give it to you, and I just still send it in the mail.
Okay.
35 mail. Well. I wish the DA is Adam Abate here?
He's right here.
Hold on. This is for you. I got your name on this. You see it still got the stamps on it.
I see it's got the stamps on it. Why don't you just give it to Deputy Gordon? He'll get it to where it needs to be.
Well, yeah, I just get copied and send a certified copy.
Okay, will it go into for it to be something that Mr. Abadi or I need to work on, it needs to also go to the clerk and get in the document?
Yeah, I'm gonna send it to the clerk.
Just
I got
send it to
the
the clerk?
copy in there too, I just didn't put it out.
Okay, make sure they get to the clerk.
Because I know you had wrote that, and I also appeared at the order of you establishing jurisdiction, which you put out 3 days later after you denied my motion to recuse. But I feel like I know for a fact that that's against law because you're supposed to cease to act on the merits of the case when I filed my recusal and grant my recusal because it was in fact notarized. So you should have never filed the order establishing jurisdiction because I was supposed to be assigned another judge.
If he weren't already locked up for murder, I'd have him jailed just for the assault he committed on the English language. And no, the case doesn't magically stop because you asked for the judge to recuse himself. That request was denied. Until a higher court says otherwise, that same judge will continue overseeing your prosecution.
Well, that's why I need to go see if there's an embossed affidavit out there.
And
If there's not,
last time we was in court, you said you were going to pause the plea arraignment, and that's another thing. You got me on the trial camera. I'm really still at my plea arraignment stage because the last time I was in court, April the 1st, you said you were going to pause the plea arraignment because remember you asked me about the issues that I had in court. You asked me why I didn't file the motions on these grounds, and I said I did. Then you looked in the computer, you seen that, you said you didn't see it, and I pulled the stamp copy out that the court clerk stamped and filed in office. Then you said, you apologized to me and said you're going to get a state to time to respond to my motion, and you were going to make your ruling. The state never responded to my motion. You still made your ruling when the state never responded to it.
I don't have to wait on the state if they don't
But
respond.
you said in court, Mr. Bedford, Judge Bedford, Your Honor.
So they have a chance to respond, but if they don't, I don't have to wait on them, and I didn't wait on them. But let me look one thing up. You said one thing that makes me a little concerned, and then I want you to spend some time with that discovery because we are moving your case along. You're not going to sit there forever just waiting for trial.
Well, if you still haven't established jurisdiction, this law state that
I'm real good with jurisdiction.
the case did not proceed until you establish jurisdiction. You can't establish jurisdiction if the Foreign Sovereign Immunity Act states that I'm immune from the state and federal jurisdiction. How can you have a jurisdiction on me if it says that I'm immune from the state and federal jurisdiction? Only time I'm not immune from state and federal jurisdiction when they are seeking money damages for personal injury or death.
You'll just have to watch.
And I filed motions on these grounds also. Then to add to that, Your Honor, the United States Constitution Amendment 5 states that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment. Your Honor, they never said that I can be arrested and charged with an affidavit for arrest. It said I can be charged on a presentment or an indictment. A presentment is a notice to the grand jury of the charges they have investigated. They're supposed to take the information that they investigated, present it to a grand jury. They were supposed to indict me, then put out an affidavit for my arrest warrant. That's violating my Fifth Amendment rights.
Okay.
And anytime the state violates the law to secure a loan, they have to dismiss these charges. And I have the most that I file have examples of Donald Trump. They investigated him, they indicted him. Then he had to turn himself right here in Fulton County. And the equal protection of law state that what you do to one person, you gotta do to all individuals, no matter the personal class. So that's a violation of my rights, John.
Well, fortunately for you, there are courts where you can challenge that if you feel like we haven't been doing it the right way here. But I'm not finding that you were ever arraigned. We've had lots of conversations.
I done been to 4 different plea arrangements, John. And I was still at my plea arrangement trying to get you. Remember, you were trying to get me to plead not guilty, and I said I cannot plead not guilty because that'll be me consenting to the court's jurisdiction.
I've said this before, and I'll say it again. Your consent is not required for a court to have jurisdiction over you. If it were, no criminal would ever agree to be tried in court.
Maybe that's what happened. You don't have to enter a plea. If you say I'm not entering a plea, then I enter the plea of not guilty for you. But it doesn't.
I disagree with that.
I understand you, and you're entitled to disagree. I feel pretty confident that the law lets me do that. But if I'm wrong, there are smarter judges that you'll get to, and you can try to convince them that that's not how it's supposed to work. But that being said, I'm gonna have to talk with my team about that. Do you want to do arraignment today?
No, I don't, because the case cannot proceed until you establish jurisdiction. You can't try to proceed with my case when you still haven't established jurisdiction. You filed an order claiming to establish jurisdiction when you wasn't supposed to cease to act upon the merits of my case.
I had already denied the motion to recuse.
I'm glad that you never had it, Honor.
Well, I'm gonna go look. Like you said,
notarized.
You told me that, and so I'm gonna go check. And so if we need to unwind all that, we can unwind all that. We can do this again. You're the one who's got all the time in the world. So you're gonna sit tight.
And this declaration of authority and son is evident. The declaration of authority is Donald Trump just signed, and it has a signature on it that he signed. It's in that package that he signed September 30th to prove that I have diplomatic immunity.
Okay. I look forward to you getting him in here as a witness, explaining how he has anything to do.
I even asked you to subpoena the governor or Brian Kemp to court to testify to these facts. I asked you to subpoena the Secretary of Washington, D.C. out to these facts, and motion that you denied on grounds that you didn't have. I've been asking for these things, Your Honor, to prove my arguments in court, but you still denied me these rights to due process.
You are literally sitting in a hearing right now, which means you are receiving due process. Subpoenaing the governor of Georgia, the Secretary of Washington, D.C., or even Donald Trump isn't suddenly going to grant you diplomatic immunity. I mean, this guy honestly has a lower IQ than a Taco Bell taco.
Okay. All right, you've got discovery. Please take that with you. I'm going to figure out the arraignment situation, and I'll see if there is this embossed affidavit connected with the motion to recuse that you filed. And if there is, then we'll need to work through your motion to recuse in a different way. If there's not, then the docket is exactly how it should be. I denied it because there was not a notarized affidavit.
You notarized.
Okay, well, you say so, but I gotta find it. If it's not with the clerk, then it wasn't notarized.
Okay. Another thing, this public servant question that I needed, is the public servant is on the Secretary of State website. It's a legal document, and it's basically states that anytime a public servant interact with a private American, these documents have to be answered and filled out before you can even ask any questions of me. So this is part of the documentation also.
Okay. It's in this envelope?
Yes.
Okay, well, then I've got it now. So I'll take a look at it. But step one is I gotta go look in the clerk's file to see if there is an embossed affidavit. And if there is, then we'll proceed accordingly. If there's not, then trial's coming up. So make sure you look through that discovery. All right? Have a good holiday. I'm still waiting the appeal that I filed on those the recuser and the standing jurisdiction. I'm still waiting to hear from them, right? And I also state that if I have an appeal pending, my case is still stuck in one spot. You're still trying to proceed with my case when I have appealed two orders that you established, and I put my notice of appeal. Both of them is pending. So how am I you're still trying to proceed with my case? What are you doing with the appeal? Have you filed anything?
I went for the Supreme Court to ask for my briefing.
Have they told you that it's been documented?
Right here also where
I don't want any more papers. It'll be in the docket, and so I'll take a look. But you're right. If your case is with the Supreme Court, then I guess you'll sit tight until they rule on it, and then if they grant you relief, we'll figure out what to do. If they deny you relief, then you will have been our guest for that many more months.
Another thing I would like to add to the record too, it was a fire at Fulton County Jail September the 12th. I'm pretty sure y'all heard about it.
Heard a little bit.
Yes, I was, I probably had my mom call and tell you about it. I was the orderly on the floor. So the sergeant that was on the floor, he froze up. I then snatched the fire extinguisher out of his hand, ran in the dome full of fire. The ceiling was on fire and everything, and got right up on this fire with a fire extinguisher that was empty. I went in this dome 3 different times and all 3 fire extinguishers were empty. The fire sprinklers never worked it. And then I collapsed and fell out and got rushed to the hospital for smoke ventilation.
How are you doing now? A little better?
Yeah, it's like now that I breathe, like my lungs, like they burning a little bit.
Yeah.
When I breathe, and I have shortage of breath since then.
Well, I appreciate you trying to do the right thing. It's too bad those fire extinguishers were empty. That's not helpful. 3 of them.
It's a lawsuit.
Okay.
And I'm in the process of filing a lawsuit now on those issues.
Okay.
Because I feel like how y'all get paid for this every day to be trained for this, and you freeze up. The officer in the booth, the officer in the tower, she left them locked in the dorm, and I took it upon myself, like, come on, they locked in the dorm, I had to do something. So I basically put my life on the line to try to save 120, 30 other inmates.
It's a shame you couldn't apply that same logic when you took the life of an innocent man who was simply walking his dog. You're a piece of garbage. And unless Donald Trump or some future president descends from the sky to personally free a convicted murderer, you're going to spend the rest of your life in a prison uniform, exactly as you deserve. With that idiot out of the way, we move on. Saving 123 inmates versus taking 1 innocent life. Next, we head to Texas for another repeat offender I've covered before, Vincent Haynes. When we last left his case, it was just weeks before his jury trial, which unfortunately wasn't streamed on YouTube. What was streamed, however, was his request for a new trial after the jury found him guilty the first time.
Case numbers G505, 4601 and 02, style of the state of Texas versus Vincent Lewis Haynes. At jury trial on November 13th, the jury found the defendant guilty of both charges and assessed punishment. The defendant filed a motion for a new trial and requested a hearing. And the state has filed a response to the defendant's motion for a new trial. And Mr. Haynes, you received a copy of that response, correct?
Correct.
Okay. All right, so Mr. Haynes, this is your motion. I'll let you go ahead and summarize your argument for the court.
Can I find out is this a court of record?
Yes, sir. We're a court of record. As I said at the start of every one of these hearings, that everything is on the record, everything is being recorded and streamed live as required by statute. And if when you had your jury trial, you were given the little pamphlet of information about how to appeal, and that's an appeal from a municipal court of record.
Okay. Okay. Right. I am a natural born living man, and I grant the court's permission to use my name for future return of my equity. I am not a corporate entity. Do you want me to present something in particular, Your Honor?
Sir, you have filed a motion for a new trial, and I'm giving you an opportunity to summarize your argument. Then the state may make their response, and then I'm going to rule. So summarize your argument for the court as to why you should receive a new trial.
Okay. I can only point to several facts. Number one, there was no one in the trial that was identified as an injured party. There's no way for me to make amends for whatever offenses the offended party would have against me. And any claims that the prosecutor may have or willed against me, I would like to know if he was doing so under the penalty of perjury. I also, basically, I am trying to make sure that the court knows that I appeared in trial only under special appearance so that I can get the facts and get any presumptions about my name and the use of my name correct.
Wrong. You're not a lawyer, so you did not appear by special appearance. You appeared by summons on a criminal complaint, and a jury has already found you guilty of those charges.
I'm going to pause right there. You were not granted any sort of special appearance. You appeared as the defendant charged in a case.
No, ma'am, I did not.
Sir, do not interrupt me. The complaint was read to you. You entered a plea, and you were not given any sort of special appearance. And this is not information that is included in the motion for new trial that you filed. So this is not an argument that you included there as I have read it. So you need to be summarizing your argument that you, in your motion for new trial that you have filed. This is your time to make your argument regarding that motion. This is not a time to raise new issues that were not.
It's not a new issue. When I told you I am a natural living person, and that even in your chambers, I did not identify with the all caps, in which you said that's only for reading purposes, and I vehemently objected and I opposed that because I don't want the presumption to go forth. So that is a part of the motion. That is a part of why the request of a new trial is.
All right, continue with your summarization.
Okay, so in order for any presumption or any assumption of me being a corporate entity where the court may see, and maybe the court may not see, that I am not a corporate entity and that I can settle and close this matter because the court should be able to identify the court's fiduciary responsibility and allow for this claim to be verified and settled on the record.
All right, is that the summary of your argument?
I mean, couple that with, like I said, there was no person in the courtroom that identified me as offending them or violating any laws.
All right, response, Mr. Bishop?
Yes, Your Honor. The defendant's motion essentially states, and I hope I'm summarizing this correctly, that he feels like his constitutional rights were violated because he did not receive due process. And I pointed the court in my motion or my response the fact that he did receive due process. He had a jury trial. He had the right to face the officer, and incidentally, the officer is the one who would be testifying under penalties of perjury. The prosecutor did not testify. I'm not a witness. The officer would testify under penalties of perjury, and he did testify. Defendant had a right to cross-examine him. It was a jury trial in front of a 6-person jury, which is the number of jurors in a misdemeanor case, and these were Class C misdemeanors. And so the defendant would not be entitled to a 12-person jury unless he was in district court, which is not the case. These are not felonies. They would not be, these are Class C misdemeanors. And so the state would point to the fact that he had a jury trial, he had a right to cross-examine the officer. The officer testified under penalties of perjury, and the jury found the defendant guilty on both offenses. And there's been no other error identified by the defendant that would warrant this court granting him a new trial.
I object.
What exactly are you objecting to? This is not the time to relitigate the facts of your case. Objections are reserved for the introduction of evidence. The prosecutor is simply presenting an argument based on the existing trial record, and you cannot object to the prosecution recounting the historical facts that led to your conviction.
Sir, hang on, Mr. Haynes. Go ahead, Mr. Bishop. Have you finished?
That's all that I have, Your Honor.
Mr. Haynes, you have an objection. You may state your objection.
Okay, I object because he's saying that the officer is the one that is testifying. The officer is a peace officer. The officer did not testify as to me hurting him. There was no one in the courtroom that identified me as offending them. The case is not against the officer. The case is the state of Texas, and the state of Texas was not in the room. I didn't see that person in the room. But the constitutional issue is I have a right to face my accuser, and there's no accuser that was identified in the room.
All right.
Therefore, due process is a part of the guarantees under the Constitution.
All right. Thank you very much. All right. The court has read and reviewed the defendant's motion for new trial with attachments and the state's response to the defendant's motion for new trial, and has heard the argument here during this hearing. This is also the same court that presided at both the pretrial hearing and the trial. I'm noting for the record that the defendant, Mr. Vincent Lewis Haynes, was advised several times that these are criminal charges which carry criminal penalties. As the defendant continues to refer to civil matters or civil approaches such as injured parties, fiduciary responsibilities, and making some sort of amends, almost as though it were a restitution. And though this is a criminal case, as the defendant was advised on multiple times during multiple court appearances, the Texas Code of Criminal Procedure, not the Texas Rules of Civil Procedure, control in a criminal court such as this. And under the Texas Code of Criminal Procedure, the defendant did receive a fair jury trial as required by the Texas Code of Criminal Procedure and the Texas rules. The defendant received a 6-person jury trial and was given the opportunity to hear the officer testify. The officer was the accusing witness. The defendant was given the right to confront the accusing witness and to cross-examine the officer. Therefore, the court is denying the defendant's motion for a new trial.
Your Honor,
Yes.
Your Honor, even now, you've never really conferred jurisdiction. You've never really established. I question jurisdiction. I've done all I can to get you, the court, to understand that I'm a natural living person. I'm a live breathing person. I'm not an artificial person.
Mr. Haynes, I understand that every defendant that appears in this court is a natural living person. And this court has jurisdiction granted by the state of Texas and the city of Dalworthing Gardens, and that has been explained to you previously at previous appearances. And once again, we went over that in the court's chambers the morning of your trial. If you still question whether that the court has jurisdiction, you might question it, but the statutes, the state laws, and the city ordinances are very clear, and this court has jurisdiction over criminal charges alleged to have occurred within the city and the territorial limits of Dalworthing Gardens. You were charged with committing 2 Class C misdemeanors within the territorial limits of the city of Dalworthing Gardens. Therefore, this court had criminal jurisdiction over your cases.
In simple terms, jurisdiction has already been established, so you can head back to your sandbox and keep licking the sand.
The court has denied your motion for new trial. You do have a right to appeal if you wish to appeal. You will need to file a written notice of appeal. You will need to file an appeal bond, which is double the amount of your fines and costs, and you'll be required to put down a deposit for the transcription of the record. And you may do that. You received the pamphlet earlier, which gave you some general information regarding the timelines, so you need to make sure that you follow the rules in regards to perfecting an appeal if you wish to do so. If not, you will need to pay your fines and costs.
Your Honor, can I ask the court a question? Do you have all the records from all of the proceedings that I've been involved in with the court?
The court does, yes. Yes.
Okay. I just wanted to make sure, because I submitted to the court a form of a bond and a non-negotiable money order, postal money order for $21.
You filed a $21 cash bond on August 6th.
Okay, do you still have that?
Yes.
Okay, all right, thank you.
And you may use that as a down payment if you wish to use that to start making payments on your fines and costs.
I can use that, ma'am, the best way I can. I'll direct the court on how that can be used.
Well, it will either be remitted to you or applied to your fines and costs. If you pay this in full in another way, that would be remitted to you. All right, make sure that you refer to the appropriate time limits regarding any sort of appeal if you wish to do so. You have 10 days to get this paid in full.
I will file a motion to appeal, but I can also verbally tell you that I'm going to appeal. So as
you have to file a written notice of appeal advising me will not.
I will file it, but the instructions also said that I can verbally say that I can appeal as well.
You may tell the court, but you do need to file a written notice of appeal, and you must post your appeal bond to perfect the appeal, and that is double the amount of the fines and costs.
All right, that wraps up today's video. We covered 3 sovereign citizen updates: one who can't escape a judge's memory, one who can't escape a future life sentence, and one who can't escape his conviction. All 3 are natural-born losers. If you enjoyed the video, hit the like button. If you didn't, hit dislike. Either way, drop a comment below and make sure to subscribe with notifications turned on so you don't miss any future content.